Hello, and welcome to Chapter 5, Part 2. In this chapter, we are going to pay attention to the procedural law and the four legal traditions. Substantive law, as we already talked about, doesn't vary much among the four legal traditions. Pretty much around the world, similar acts are recognized as being criminal. Punishments differ, but generally speaking, they are proportional in context to the crime being committed. Also, generally speaking, questions about things like intent and criminal responsibility are a bit more problematic, but for the most part, criminal justice systems around the world recognize such things as duress, immaturity, self-defense, those types of things as being similar in the sense of having to reduce criminal responsibility. Also, generally speaking, although intent can be described differently, in most jurisdictions there is some attempt to make a reference to intent. However, greater differences are found among the traditions in terms of criminal procedure. And we see that when talking specifically about the adjudicatory process. When we're using the term adjudication, we're talking about the process of examining the facts in a disagreement and rendering a decision. Now, there are different ways that one can go about doing this. Our particular concern, and the concern of most countries, is how do we determine if a government is correct in its accusation against a defendant? This is similar to the rule of law that we'll be talking about a little bit later. This process has been defined or described as falling into two broad camps. There can be some others which are maybe mixtures of these two, and maybe some that are rather different than either of these. But for the most part, we talk about the adjudicatory process as being either adversarial in nature or inquisitorial in nature. As we'll see near the end of this part, the Islamic and Eastern Asian systems present some differences. An important thing to remember as we're going through all of this is that both the adversarial and the inquisitorial systems have a similar goal in mind. They both have finding truth as being a fundamental aim. And each is also guided by the principle that the guilty should be punished and the innocent should be left alone. This chart, which is a reprint of one that's found in your textbook as well, is a fairly easy way to look at how the adversarial and inquisitorial systems can be distinguished. This happens to be table 5.1 in your textbook. The first question is, who is the accuser? Who plays that role? Under the adversarial system, the accuser moves from the individual to the state in a continuation of private vengeance. Where we get this idea is, as we talked about in an earlier chapter, under a common law, for example, the first common laws were seen as being acts or crimes against the community itself. More specifically, the community was being represented by the lord of the manor, for example, initially, and then as we moved away from the manorial system, the monarchs came in, and so the monarch was seen as being the representation of the private vengeance. So if you are the king or queen and someone has harmed one of your subjects, they have harmed you. We see that even the way that cases are phrased. The regent versus Smith or Jones. And today, of course, we have it in terms of the state. Once we move from monarchies into more democracies, parliamentarian systems, and so on, legislators, then we have the people against Smith, or the state of Colorado against Smith. In each of these instances, the idea is that we have moved from the idea of private vengeance and individuals seeking some kind of justice to the state representing that individual. Under the inquisitorial system, the state replaces the individual, doesn't just represent the individual, but actually replaces the individual in a substitution for vengeance. Now, this is an interesting idea and one that's very difficult for those of us who basically live in an adversarial system. The idea here under the inquisitorial system is that the state is taking action on the part of the state itself. It isn't really representing the victim in the sense that we would think of the victim being represented. This has some implications in terms of how the general public even views the role of what we would call the prosecutor, for example, and the role of the court itself. You aren't necessarily representing me as a victim, if you're the procurator, that would be called, or the prosecutor, but I understand that you are representing the state. And because of that, my interests might not play as much of a role as they would under the adversarial system, for example. So how is truth determined? Well, under the adversarial system, truth is said to arise from competition. And here the emphasis is on the trial, where the competition can actually be seen in action. The state versus the defense, versus in the sense that they are both trying to put forward the facts as they see them, and in doing so, finding the truth through this competition of examination, cross-examination, etc. Under the inquisitorial system, however, truth is said to arise from a continuing investigation. Because of this, the emphasis is not so much on the trial stage as it is on the pre-trial stage, where you are doing the investigation of the alleged offense. Also, we see more of the individuals involved in the inquisitorial system. As we'll talk about later, you even have a representative from the judiciary involved in the investigative stage, in addition to the prosecution and defense. And all those people are said to be working together to determine what happened, determine what the truth is. So it's not a competition as much as it is a cooperative effort in investigation. So where does the power lie? Well, under the adversarial system, the power is shared with amongst the various players, with the judge serving primarily as a referee. Under the inquisitorial system, on the other hand, the power more clearly lies with the judge. Again, we'll see some examples of this as we get further into it. The judge, for example, under an inquisitorial system will be the one that decides which witnesses will be heard from, will be the one who questions the witnesses. If either of the attorneys for prosecution or defense want to ask questions, they do so with the judge's permission. So the judge has a much more clear and important role. I won't say important role, but certainly a more clear and maybe more powerful role than they do in the adversarial system. Expected cooperation, this refers to the idea of the defendant. To what extent do we expect the defendant to cooperate in the investigation? And under the adversarial system, it is neither expected nor required. The defendant is not believed to have to play much of a role in determining how the charges will progress. It's entirely up to the state to prove the charges against the individual. Under the inquisitorial system, however, the seeking of the truth by all parties involved means that you kind of expect the defendant to be involved in this and to help figure out what the truth is. They aren't required to do so, so you don't have to admit guilt, for example. You don't have to divulge information that you choose not to. But if you don't, then it's not so much that it can be held against you, but it can be brought to the attention of the judges, for example, during a trial. So you're expected but not required to cooperate under the inquisitorial system. Again, we'll see some examples of that later. Under the adversarial system, you're neither expected nor required to cooperate in the proceedings. Let's talk a little bit more about the inquisitorial system. We think of it as primarily a continuation of investigation. The trial is simply the final stage of that investigation process. Again, the trial doesn't play a similar kind of role as it does in the adversarial system. Instead, from the time the person is arrested and if they're placed in detention, all the various parties are trying to figure out what happened. This brings to mind that idea that we had talked about in Chapter 3 of factual guilt. That is, what truly went on in the situation? Did this person in fact commit this crime? And the way you go about doing that is by having all the parties involved, including the judiciary, during the investigation stage. Now, because of this effort that's put in during the investigation, many people would argue that a goal of the inquisitorial system is to exclude, even prior to the trial stage, those people who are likely to be innocent, as opposed to the adversarial system, where the trial is really the place where the truth comes out, as it were. And so we move to trial more quickly in the adversarial system. The inquisitorial system, you could be under investigation for a much longer period of time. The trade-off is that under the inquisitorial system, you might not ever get to the trial because charges have been dismissed if it's shown that you probably didn't commit the crime. Under the adversarial system, you move more quickly to the trial, and in doing so, you have your chance in court. You have your opportunity to force the state, the government, to prove their charges against you. Since the trial is a continuation of the investigation stage on the inquisitorial system, a confession is simply another piece of evidence. You can certainly admit to the charges, but if you do so, it doesn't stop the proceedings. It doesn't move you directly to a sentencing stage, for example. Instead, when you get to trial, as the final stage of the investigation, your confession is simply included as part of the discussion, the evidence, as it were. This plays an important role in determining what the punishment might be or what the sentence might be. And again, we'll be coming back to that a little bit later because sentencing is seen as being a little bit different under the inquisitorial system. There really isn't any plea bargaining in the sense that the United States has it. The reason for this is what's referred to as the principle of legality. The prosecutor under the inquisitorial system has to bring charges that are alleged to have been committed, not what the person is willing to admit to. So if a person is charged with theft, then the principle of legality requires the prosecutor to bring charges of theft. Even if you could get the person to plead guilty to trespass, for example, as part of a theft, or maybe a burglary would be a better example of that, that would not be appropriate because if the person really did burglary, you need to charge them with burglary. If the person only did trespass, then you should only charge them with trespass. Now actually, as a practical matter, there really is plea bargaining in most of the, I should say many, if not most, of the inquisitorial processes. Germany and France are both referred to in your textbook as being examples of plea bargaining that maybe neither the Germans nor the French would say is a clear example of that. They have some ways that would still allow them to fit and meet the principle of legality, even though from U.S. eyes it might be seen as just another example of plea bargaining. I encourage you to see the reading on plea bargaining that you'll find in Module 7. Continuing with the inquisitorial system, the question often is asked, is the defendant presumed guilty under the inquisitorial process upon arrival in court? And that's oftentimes a criticism of the inquisitorial system. The idea that you oftentimes hear the layperson say, or sometimes in movies and television, under the inquisitorial system, you are assumed guilty and it's your responsibility to prove your innocence. And that's really a misinterpretation of the way the inquisitorial process operates. The investigatory process itself is supposed to determine an accused person's guilt or innocence. And then only those who are determined to be guilty are taken to court, because if you weren't determined to be guilty, if you weren't believed strongly to be guilty, then you should be dropped out of the system during the investigation stage, which could be very early on, or it could be after a couple of weeks as more investigation takes place. Again, keep in mind that the determination of the truth doesn't have to wait until the trial stage. You have defense, prosecution, and judiciary representatives all involved in the investigation. And so presumably anybody who is innocent will be excluded in that investigatory process, and then who you are left with are those that are most likely to be guilty, ending up in court. And so I can kind of see why the media and others might interpret this as being you're guilty and you must prove your innocence, but it's a misunderstanding of what role the trial actually plays in the inquisitorial process. It's this point that leads some to argue, as you said, that the defense presumed guilty, but again I see that as being a misinterpretation of how the trial under the inquisitorial system operates. The adversarial system, the struggle is between two sides. Sometimes this is called a sporting theory of justice, developed from the old trials by ordeal, where the person who was deemed the victor was said to have truth on his side. so that you were engaged in battles, or you were made to undergo various kinds of trials, sticking your hand into a pot of boiling water and having it wrapped, and then when it's unwrapped, if it was healing, God was on your side, for example, and therefore you must be innocent. So those kind of things were developed, but the idea that eventually we have some kind of procedure overtaking this process of trial by combat, and each side uses procedure or uses the law to gain a particular advantage, as opposed to using swords or guns or some other kind of more obvious sporting theory. So one of those swords is the process of cross-examination, which is used to challenge or to destroy a witness's testimony. In this manner, you have either prosecution or defense given the opportunity to cross-examine a witness and try to challenge that witness's story. The checks and balances process allows a sharing of power amongst the judge, the prosecution, defense, and even the jurors. And in this sense, the battlefields are said to be more fair, because the power is dispersed amongst all these roles, these players in the process, unlike in the inquisitorial system where the judge has more primary role. In this next slide, we see a way to kind of highlight these contrasts that I've been talking about. Under the adversarial system, the trial phase is emphasized. Under the inquisitorial system, the screening phase is emphasized. Under the adversarial system, the judiciary's involvement is very restricted in both the investigative and even in the adjudicatory stage. But under the inquisitorial process, the judiciary has quite a bit of involvement, even in the investigation stage and certainly in the adjudicatory stage. As I said, even to the point where they were calling witnesses and asking questions. Under the adversarial process, the burden of proof is on the prosecution. The defendant will essentially be silent, or is expected to be silent. Under the inquisitorial system, on the other hand, everyone, even the defendant, is expected to cooperate in seeking the truth. Again, a reminder that the defendant is expected but not required to participate. Under the adversarial process, the judge serves as a referee, the attorneys present sides, the jury decides, or if it's a judge or bench trial, the judge decides between the two versions of the truth. Under the inquisitorial process, in addition to deciding the case, the judge will also, as I said, determine which witnesses will be asked, what questions will be asked, what evidence will even be presented, and will also make a summation that argues how the various facts should be interpreted. That's a brief overview of the two primary procedures, inquisitorial and adversarial. In the next part, we're going to look at how Islamic law and the Eastern Asian traditions are kind of variations of what we have just talked about. Neither one of them fit nicely into either adversarial or Islamic descriptions. Thank you for your attention.